Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
The attorney of fact.
Attorney what?
Of fact.
Attorney of fact. And what does that mean?
You know, his authorization to do legal representation.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
Today's courtroom hearing was hard to believe. The man in court was identified in the paperwork as Matthew Aldridge, but once he stepped up to the podium, he started claiming he wasn't actually that person. Instead, he called himself an attorney of fact, a title that has no real standing in the legal system. People who follow these types of legal theories often argue that courts have no authority over them, but that argument almost never works. Courts still have legal power over anyone within their area, and the judge in this case made that very clear right away.
Yes, sir.
I don't have.
You don't have a name? Pardon?
I'm the attorney of fact for the respondent mayor.
Well, let me explain to you. Only an attorney at law can stand in court and represent a criminal defendant. And to do so otherwise violates the criminal law statutes of the state of Tennessee and could land someone who attempts to represent themselves as an attorney at law in serious trouble. I understand what you're saying. I understand you're saying an attorney in fact. And what I want you to understand is that if you have a power of attorney, then you need to demonstrate that power of attorney. Do you have a legal document called a power of attorney?
No, I do not this time.
Okay. Then you don't have any authority to act on behalf of Matthew Aldridge in this court. You have no legal authority, nor do you have any authority through a legal document to represent or to act on behalf of Matthew Aldridge.
Why don't we court just let me file this document?
Show it to the bailiff and he'll show it to me. Apparently there's a copy here.
From the beginning, it was obvious the judge was not interested in entertaining these claims and quickly stopped the argument before it went any further. At one point, the man even handed the judge a document that supposedly gave him the right to represent Matthew Aldridge. The paper referenced questionable legal ideas that do not actually hold up in court. Real attorneys must be licensed and follow official legal procedures, not rely on self-created paperwork or misunderstood legal language. The judge handled the situation calmly and professionally the entire time. Every time the man tried to push one of these arguments, the judge immediately addressed it and moved the hearing forward.
Well, I find that Matthew Neal Aldridge has failed to appear personally in this court for the plea day on his case, which is set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neal Aldridge. If you are, in fact, Matthew Neal Aldridge, then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee, and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally on what we call our last plea day before his trial date tomorrow.
Is that an Article 3 trial?
To what?
Will that be an Article 3 trial? A trial by jury with jury?
It would be a trial by jury. Certainly it would be. But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court, and you're wasting valuable time to all of these other citizens who are here today. So when I'm talking, you stop talking. No, you will when I'm finished talking. You are wasting the court's time by doing this, and I'm just simply instructing you that if you are in fact Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately, it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge. All right. To Matthew Aldridge and the individual standing before me whose name must not be altered,
One moment that really stood out was when the judge responded to the man refusing to state his name. It added an unexpected moment to an otherwise tense hearing. These kinds of courtroom arguments are often linked to the sovereign citizen movement. Supporters believe they can avoid certain laws by rejecting government authority or misusing legal terms connected to common law or the Uniform Commercial Code. In reality, courts operate under established federal, state, and local laws that apply regardless of personal beliefs.
Then we will set a July 15th trial date for Mr. Aldridge. Whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore I'm denying whatever that might be in the way of a motion. The trial date will be July 15th. The last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are in fact Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get this card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will be will take place with him in jail, incarcerated on the 15th. That's the judgment of the court. You need to take your piece of paper and go.
Judges across the country have seen these arguments many times before, and they rarely lead to success in court. In some cases, they can even create more legal problems by delaying proceedings or ignoring lawful instructions. At the end of the day, this hearing showed how quickly these claims fall apart when challenged in a real courtroom. The judge stayed composed, followed the law, and did not allow the situation to turn into a distraction. Thanks for watching, and feel free to share your thoughts on these courtroom strategies in the comments.